What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
And welcome back to the Zona Law podcast. I am Mark Zinman, joined here today by Scott Baluha.
Good afternoon, Mark. What are we here talking about today?
Today is part 2 in the Fair Housing series, a 5-part series. It's just thrilling. Part 2 is accommodations and modifications. Where do we even start, Scott?
I would say that not a week goes by that I don't get multiple requests from clients in this particular area. There's a lot of confusion when it comes to what you can and cannot ask for when a resident may or may not have a disability, and they're asking for accommodations to alleviate any of the symptoms of that disability.
Yeah, so this is an incredibly critical thing for managers to understand and know about, because more than 50% of all fair housing complaints at this time relate to disability. So on a national level, we've got race, color, national origin, sex, familial status, disability discrimination, and sex, if I didn't say it. 7 of them. But as I said, disability is by far the volume number 1. And a big part of that is not just simply you rent to me or you don't rent to me, but rather you grant an accommodation or you don't grant a modification. So what is a reasonable accommodation?
And Mark, that's actually a good point, is that it doesn't matter when in the tenancy that a tenant comes up to you and asks for a reasonable accommodation. But generally, Mark, a reasonable accommodation is in order for residents or tenants to have equal use and enjoyment of the property. Sometimes there's different changes that a property or a landlord may need to make in order to accommodate somebody with a disability. So that's kind of the starting point for all of this analysis.
Yeah, and before we jump into the nuts and bolts of it, we got 2 big disclaimers. Anytime you're talking about reasonable accommodations or modifications, you have to realize they're fact-specific analysis. So we're going to talk, obviously, just because Scott and I are attorneys and we like to talk, so we'll kind of walk through the big picture. But every time a fair housing issue, an accommodation or modification issue comes up, it's fact-based, and you have to talk to your attorney and walk through it. And then also, of course, if on an accommodation or modification you're not going to grant it, you still have to engage in the interactive process. So what is the interactive process?
Well, generally the interactive process can take place via email, via phone call, via in-person communications, where essentially you're having a discussion with the resident about, well, what is the nature of the disability and what is the nature of the accommodation that the resident is asking for, so that they have equal use and enjoyment of the property. And one of the reasons why you need to have that conversation is to make sure to limit your liability when it comes to potential fair housing complaints. As Mark mentioned, 50% of them are all disability related, and oftentimes the penalties, if there is a violation, are severe. So essentially starting with that interactive process and having that conversation is essentially what most fair housing investigators are going to be looking for. Did you have a conversation about this issue with the resident?
Yeah, as we're going to explain, a lot with reasonable accommodations is whether it's reasonable or not. And that's, very subjective to some extent. And so as long as you're engaging the interactive process, you're having that dialogue with your residents, that's the most important thing. So jumping in with reasonable accommodation. So a reasonable accommodation is a change in your policy or procedure to allow a resident to reasonably use and enjoy your property, to account for the disability, to have them, like Scott said, allow equal access and use of the property just like anybody else. What's the most common reasonable accommodation request you see?
Well, the number one question that I get from managers comes down to the emotional support animal, assistive animal, service animal. Oftentimes, this comes up in the context of a resident saying, well, they moved in an animal without knowledge by the community. The community wants to start assessing pet deposits, pet fees, and everything else. There's a process that you have to go through in order to waive the pet deposits and waive the pet rent, and that all starts with making a determination of is there a disability? Well, how do you determine that?
Yeah, and so the first question right off the bat is the tenant's asking you to do something, right? I want you to waive a policy, I waive a procedure. Don't charge me the pet fee, don't charge me the pet rent. And it's because the person's disabled. So you need some sort of confirmation that they're disabled, which can come from either medical verification, or if the disability is open and obvious, you don't need any sort of verification. If somebody comes in and they're blind and they need a seeing eye dog, it's obvious. You wouldn't ask for a doctor's note. They need that seeing eye dog. But it's different with assistance animals when it's an emotional support animal. So you can seek verification.
Correct, and oftentimes it's something that's not open and obvious. If somebody has anxiety, PTSD, depression, you're not going to be able to see those things. And one of the key things to remember is that you're not a medical professional. You can't make that determination as to whether or not there is a need unless it's open and obvious, such as the use of a wheelchair or having a seeing eye dog. And when we say medical provider, it doesn't have to always be a doctor. It could be a counselor. It could be a nurse practitioner. There are many different types of categories, which is a key element here. Oftentimes, I have managers say, well, I didn't get the note from a doctor. Well, it doesn't always need to be a doctor.
Yeah, it could be a nurse. There's a large capability of what the potential options are. What's important for managers, though, and where people really get confused a lot, is that you can't ask what the nature and extent of the disability is. The doctor's note is just to confirm that the person is disabled, and then you get to the second part of the second question, really, which is, what do they need to reasonably use and enjoy the property? So there has to be some sort of connection. Yes, they're disabled, and they're asking for X, and X is what they need to be able to reasonably use and enjoy the property. So walking those lines, explain it to us how it would work with somebody coming in with anxiety, and then how does that tie in with an assistance animal?
Sure. So oftentimes when you ask for reliable documentation from a medical provider showing the disability-related need, oftentimes you will receive a document. And kind of like a side conversation on that is oftentimes the manager will be presented with a card, which oftentimes many residents can obtain off of the internet that says service animal or emotional support animal. Is that meet the standard for reliable documentation from a medical provider?
No, because that's just something you buy, and we talked about that as well, is that it's just simply not enough. It's not confirming that the person themselves is disabled or that they need that animal to reasonably use and enjoy the property. But let's jump actually here for a second because we obviously talk about assistance animals a lot. Let's jump to a different one. What about somebody that's on SSDI, Social Security Disability Income, gets their check from the government on the 3rd, but rent's due on the 1st, late fees kick on the 2nd, and they say, hey, can I pay my rent on the 4th without late fees? Is that a reasonable accommodation?
Yeah, I would argue that, yes, that is a reasonable accommodation. You're not foregoing any potential losses or damages as a result of waiting the additional day and foregoing that 1 day of late fees. If the individual has explained to you that they have a disability, they provided the appropriate documentation from a medical provider, then we would argue that is a reasonable accommodation.
Yeah, and in that one, you might not even need documentation from a medical provider anyways, because if you have the SSDI proof of payment, that is confirmation enough that the person is disabled. And so then you come back to those questions, right? Always come back to that. That's what I was like, what are the rules? Let's go back to them. So the first question is the person disabled? Well, yes, they have SSDI. 2 is, do they need something to reasonably use and enjoy the property? And potentially, that they're going to be penalized otherwise for getting their payments in the time they do. And then the third and final question is it reasonable? And that's always where I said it's a bit more subjective, but yeah, what Scott's saying is waiting 1 day before you assess late fees, clearly that's going to be reasonable, because under the law, reasonable is whether it's a financial or administrative hardship or somehow alters the business of the manager.
And another caveat here, when we talk about these issues in the context of reasonableness, we also have to look at it from the standpoint of there's not a lot of bright line rules that give us specific guidance as to what the housing administration will determine to be a violation or not to be a violation. There are certain things that we have black and white answers for, but a lot of gray area exists in this area of law, which is why, again, it's essential that you have that communication with your regional manager and potentially with your attorneys so that you can have that back and forth before you make a determination as to whether or not to grant or not grant a reasonable accommodation.
Yeah, and that's where the interactive process, you come in and talk. Like I imagine, for example, the other side. We always talk about accommodations that are granted, but think about for a second if you had like a 10-unit apartment community or even a 500-unit apartment community, and a tenant says, hey, I'm disabled, I'm unable to get my trash out. Can you, as the manager now, come and get my trash for me every night and take it to the garbage? Is that a reasonable accommodation?
I mean, you have to think about that in the context of what current processes are already in place, what kind of administrative expenses would end up being added to the community in order to accommodate that particular request. From my perspective, that would not be a reasonable accommodation, because now you're inserting a brand new process and new administrative costs into the organization that didn't exist before. Now, it might be a little bit different if the community had already taken on that obligation for several years. The analysis might shift if you change the facts a little bit, which again, why you have to have that interactive process.
It's
right?
a tough one, right?
Right.
It's always based on the facts, where if you're changing the nature of the business, that's not reasonable. But if they're already providing that service, then maybe it is.
So what if you had a valet? Many communities have valet services in which they charge $19.95 or some de minimis amount in order to pick up individuals' trash. Is it a reasonable accommodation to waive that $20 fee for somebody that is disabled? What do you think?
I don't think so, because I think that's part of actually renting the property. It's no different than somebody that, if they want one of the assigned parking spots, if they want to live in that property. I know a lot of apartments break out the different charges, but that's effectively part of the rent that is everybody has to pay.
Right.
That's not different than somebody wants to bring an assistive animal and they're specifically getting that extra thing, and that's different. So I don't think so. But really with the reasonable accommodations is the person disabled? And again, you can't ask for that nature and extent, just simply confirmation of some sort, either it's open and obvious or the medical letter, whether or not do they need it to reasonably use and enjoy the property, and then 3, whether or not it's reasonable, which is financial, administrative, or just changing the nature of the business.
Right. Yeah, and again, because it's so fact-intensive, again, you're going to want to walk through that analysis. You never want to make a quick judgment as to yes or no. If there's one thing that we can impart on you that's the most important thing, is always pause for a moment, collect the appropriate information and data before you make a decision. I have it happen too often where somebody is jumping the gun and saying, oh, well, this documentation isn't sufficient enough. Well, it's not enough to say, well, you're going to make another request. Well, do you have any other documentation? You want to appear as forthcoming in terms of gathering the data as you possibly can.
Yeah, and we've written tons of letters saying, hey, we're conditionally denying your request as it is, but we're happy to review any more documentation you bring, which is a great way to do it, so at least you keep kind of the dialogue going and engage in that interactive process.
And another context in which this often comes up is in terms of requesting a caregiver. We have many clients that have 55-plus communities where they're asking for a caregiver to move in that otherwise doesn't meet the age qualification. Well, is it a reasonable accommodation to basically waive that 55-plus or secondary age cutoff in order to allow the caregiver to come in? You're going to, again, same thing as if it's an emotional support animal, same thing for requesting trash service or everything else. Where do we start? Start with having that determination of whether or not there's a disability, asking for the appropriate documentation, and again, engaging in that interactive process.
I think this is actually something Scott and I did not discuss ahead of time. So I actually do think this is a brilliant example, though, because if you look to that, Scott, let's say the person has, if people don't know, when you have a 55-plus community and they may have a secondary age saying you must be above 45, for example, but the primary person is over that. And so we need a caregiver. I'm disabled. The person is actually 30, and therefore we waive that for them as an accommodation. So generally the concept is that's a reasonable accommodation. You have to waive that secondary age. It's a policy or procedure, and you waive it to allow the person to be there. But what if it turns out the caregiver is a sex offender? Now what was reasonable suddenly is unreasonable, because now you have a person that wouldn't pass your criminal background standard, that everybody else in the community is going to get this sex registration information, and that's where it goes from reasonable to unreasonable.
Yeah, and it's essential if you're in a manufactured housing community or if you're in an RV resort. There are specific statutes that talk about requests for caregivers, and my recommendation is to ensure that your rules and regulations, your policies, your community guidelines, if you're in the apartment world, that you have specific provisions in there that talk about needing to go through a credit and criminal, well, not credit, but just the criminal background check for somebody to be coming in either as an authorized occupant or as a caregiver.
Yeah, absolutely. And in the apartment world, we don't have that same statute that we do in the MH and the RV world. So let's jump over to modifications. And before we do that, by the way, does anybody appreciate the nice Zona logo as opposed to the red cup we had for part 1?
Yes, it blends into the background much easier than the red cup says.
Probably looks a little more professional, but
right.
It is what it is. All right, modification. So tell me, Scott Baluha, what is a reasonable modification?
So in this circumstance that I usually have the questions come from managers is you have a resident that's coming in that says, I want to make, or the tenant is requesting that they somehow change the structure of the unit. The most common one is installing grab bars in showers or putting an access ramp into the entrance of the unit. In that circumstance, you're going to end up engaging in that same interactive process. But what are some other examples that you've seen in this context?
Oh, I've seen a ton. I mean, you have, obviously, I think the grab bar is by volume the number one. What people have put in walk-in showers, for example, like kind of what you see in the infomercials in the middle of the night. Ramps are big. I've even seen in kitchens where the cabinets up top in the kitchen are permitted to be reduced, put down onto the ground. Because if you're in a wheelchair and you go into an apartment or a home and there's cabinets on the top, those are largely useless for you. And so what a reasonable modification is a physical change to the structure of the building to allow the person to reasonably use and enjoy the property.
And another common request as well is being able to have hardwood floors in a unit where otherwise you have carpeting and somebody needs access to the unit via wheelchair. Well, it's more difficult to move around in the unit on carpeting. So sometimes the request is, well, can you put in tile or can you put in hardwood floors so that I'll have easier access to the unit? What's the first step there?
Same thing as you as with a accommodation, with the modification is first, is the person disabled? And of course, in the case of the wheelchair where the person just needs a hard surface, obviously they're disabled, no question about that. And then the second question is, do they need the accommodation, or well, in this case, modification to reasonably use and enjoy the property? I think it's pretty obvious that carpet is not as effective for tile, linoleum, or even just some people, we've seen requests where the person just wants the carpet ripped up and leave the actual cement floor, provided that it's good enough quality. And that's obviously as well. And then the question comes down to reasonableness. And in every case, that's no question it's going to become reasonable. But the big thing for modifications is if there's a cost to the physical change of structure of the building, generally that's borne by the resident, meaning the tenant pays. So if a tenant wants to put in a walk-in shower, which those can be expensive, it's the tenant's liability to do that. Obviously, you have to use a contractor, but it's the tenant that has to pay for it, not the landlord.
So let's say that in the circumstance of somebody wanting the removal of the carpet in order to put in hardwood flooring. Now, let's say that ends up causing the value of the unit to increase. Well, should the tenant in that circumstance bear 100% of the cost if the unit is going to be somehow improved by the installation of the flooring?
If it's going to be improved, I guess not. I mean, you're going to have to go very fact-specific into that, though,
right.
Because if it's something that they've never done in that property before and that specific tenant's just saying, I need linoleum or I need tile, to me it's still on the tenant's burden. If there's some sort of set-off, I guess you could look to that. But the general default, of course, is that it's the tenant's cost to incur.
Right. And then what about if there's damages that end up being incurred in the property as a result of the use of it? In other words, there's dings in the cabinets or there's other physical damages to the structure. Is it a reasonable or is it a modification or a reasonable accommodation to allow those damages to occur without the landlord being compensated for them?
No. Whenever a tenant moves out and there's damage to the unit, if it's not returned in the same condition it was received in, you can charge the tenant for those damages. And under these modifications as well, if there's a substantial modification that's being done, let's give the example of cabinets from up top being put on the ground so that somebody in a wheelchair can use them. You can even, as the landlord, potentially ask for a deposit to cover the return of those cabinets back the way they were. That's obviously something very nuanced in the act, and you really want to talk to your attorney about that. But realize, yes, you're allowing a person to change the structure so they can reasonably use and enjoy the property, but it's not like you're just hands-off entirely. I mean, there are a lot of things you can do to make sure that you're protected, make sure it's done good quality, and that you get the property back the way it was intended to be.
Right. And another context in which we hear these types of requests come up is resident or tenant makes a request for some type of physical structural change outside of where the unit is, either access to a clubhouse, access to a pool facility, or other facilities that are inside the apartment complex. So what do you do in those circumstances that it's not necessarily in the tenant's unit?
You notice just for a second that Baluha gave me the hardest question out of this whole podcast. Okay, so we're going to go nuance, but hold on, let's get this done. All right, short answer is if it's within the private area of the community, so like the pool, clubhouse, any areas that are just for the residents, that's generally the tenant's responsibility to pay for it. if you're in what I consider the public area, which is governed by the ADA, so your office or like your parking out front for guest residents, that's ADA, and basically it's up to the landlord to keep that up to date with the law and retrofit, if you will. If it's inside the community, though, it's the tenant's responsibility. So if the most common obvious example of that is a pool lift, a chair lift, where hotels, for example, are governed by the ADA. They're public. Hotels have to have a chair lift. Whereas under fair housing, where you have a private pool for just the apartment, the residents, you don't have to have one. So if a tenant wants a chair lift, it's actually at the tenant's expense that they would put a chair lift in. And you'd look at the reasonable modification analysis. Is the person disabled? Do they need that to reasonably use and enjoy the pool? And is it reasonable? And all of those are checked. And so then the tenant has to pay for that modification.
Correct. Yes. And another context and another asterisk that we have to put on this, because there's so many little asterisks when it comes to this particular area of the law, is there are some RV resorts that frequently have events in which they invite members of outside the community. In other words, not necessarily in the RV resort itself, but outside nearby neighborhoods that are not affiliated with them. And they have these public events that they cause people to come in, either to their auditoriums or to their public pools or other places. So in that circumstance, the analysis might shift where we have to look at it under the ADA, in which case you may be required to install a pool lift, or you may be required to install certain facilities to allow for the disabilities. But as a general rule, when it comes to areas that are exclusively for the use of the residents and their guests, they can request the modification, and once the request is granted, that cost could be borne by the resident or the tenant making the request under fair housing.
And before we wrap it up, I have one critical extra point as well that always comes up is, what form of documentation can you require if you're seeking verification that the person is disabled and that they reasonably need these changes, whether accommodation or modification? You can always, and you should as a matter of policy, give out your company form for reasonable accommodation. But if you get a doctor's note back, you can't require it be in your form. Accommodations across the board don't necessarily even have to be in writing. They can come in just oral, depending on what the situation is as well. The best to always give the form as a backup, but what comes back to you, and you still have to engage in that interactive process. You still have to determine the reasonableness of the accommodation or modification, even if it's not on your form.
And that is true when it comes to signing off on any type of documentation. When it comes to approving a caregiver or approving a pet, it's not as though you can now require that a pet form be filled out. You cannot require that a caregiver fill out this. As Mark said, sometimes it's enough to have oral confirmation when it comes to granting a reasonable modification.
Yeah, so we know we just threw a ton of information at you. Maybe watch it 2 or 3 times, get our views up so you understand the stuff. But of course, always talk to your attorney if you guys have any questions about this stuff. The worst thing, like Scott said, is that you can do that gut reaction where you just tell somebody an answer and it turns out to be wrong.
Correct.
There's nothing wrong with taking a breath, talking to your attorney, talking to your corporate office, and getting back to a resident with an answer.
Yep, there's nothing that says that you have to respond within 30 seconds. Most times under fair housing, they want you to take the time to engage in that process, and that process alone will be what's necessary in order to comply with fair housing rules.
Yeah, so thank you guys for being here. We can't wait to see you next time at the Zona Law Podcast.